Hi there, class. This video focuses on the customary details included in term sheets. We'll kick this video off with a quote from LinkedIn co-founder Reid Hoffman in his own words.
The metaphor that I use for entrepreneurship is you jump off a cliff and you assemble the airplane on the way down.
Thanks, Reid. Our agenda for this video is the simplest yet. It's all about term sheets. When a VC decides it is interested in your company, it will issue a term sheet. The design and structure of term sheets was originally developed by these law firms on the East and West Coast, respectively. These are the term sheet OGs. There are a lot of details to be worked out in a venture investment. So, what purpose do term sheets serve? Well, term sheets are a way to get the key terms of the deal worked out up front and come to an agreement on the basics before you spend a bunch of money on lawyers. I found that this is an effective way of negotiating other legal agreements as well, but it was pioneered in the world of venture capital. Now, a term sheet is non-binding. The VC doesn't have to go through with the deal, and neither do you, even after it's signed. It is uncommon, however, for VCs to arbitrarily back out of a term sheet, and there is significant reputational risk attached to doing so, but it does happen. It's best to view a term sheet as an expression of interest and good faith between the parties as they work towards a deal. Accepting a term sheet may mean you're agreeing to pursue a deal exclusively with that investor, so be wary of that. A term sheet that is issued but yet unsigned can be a tool to leverage while negotiating with other investors. There are not a lot of places to read up on term sheets. You will have read most of these provisions that we're talking about in this video in Venture Deals. Another good resource is this little book called Term Sheets and Valuations. Now, this list includes the basic sections of a term sheet. Not all of these sections are used by every investor. The first section, or Preamble, offers the basics. It's kind of a mini PPM in that it often contains disclosures. It's not required, but when it's used, it outlines the basic length of time in order to put a deal together and may include a no-shop clause. In other words, if you sign, you're agreeing to pursue a deal exclusively with this VC for the duration that is specified. The term sheet also outlines the new securities to be issued. It includes the terms for the type of new shares, such as what class and/or series of equity will be issued, and how these shares will fall within the capital stack. In addition to the type of shares, the total amount raised, the number of shares, and the price per share are articulated. In other words, all the key elements for calculating your company valuation. This is summed up in what your anticipated post-investment cap table will look like. One of the most concise rules I've read for understanding term sheets is this quote from the author of your textbook, Venture Deals. There are only two things that VCs really care about when making investments: economics and control. As you consider how each term impacts the economics of the deal and the control of the company, you get a good idea of which terms are most important to your investor. Term sheets may, but are not required to, include dividend provisions. Dividends are money paid out to investors annually based on the amount invested. The board has the authority to issue dividends, but may have its hands tied by these provisions. Key things to know. Is your investor requesting dividends as part of the deal or not? If so, how does that affect the deal? Then, are the dividends cumulative or not? Non-cumulative dividends are sometimes called regular dividends. Let's say the company gets to the end of the year and it cannot afford to pay a dividend. In the case of cumulative dividends, the obligation to pay for the year accrues. For regular dividends, on the other hand, hey, nobody got a dividend this year, better luck next year. A preference on dividends makes dividends payable to the investor, technically the preferred shareholders, before paying any dividends to holders of subordinate classes of stock. Cumulative and preferred dividends are provisions that potentially allow investors to jump ahead in line when it comes time to divvy up the money. Next is a really important term to understand. This is the liquidation preference, and it's a biggie. The key thing to understand here is that if the company has a liquidity event, such as a sale or IPO, investors holding liquidation preferences move to the front of the line. It's common for liquidation preferences to be 1 times the amount invested. This essentially puts the return of investors' capital first, before anyone receives anything else. Liquidation preferences can be higher than 1 to 1, like you could have a 2 to 1 liquidation preference. Your text gives a really good treatment of some of the variations on liquidation preferences. The main thing I want you to know is how this affects you as a founder. Here's a quick example. Let's say that you raise $5 million from an investor for a third of the company, and he has a 1 to 1 liquidation preference. Then you sell your company for $15 million. You might be saying, hey, I own 2/3, he owns 1/3. That would mean I get $10 million and he gets $5 million, right? Wrong. The investor takes $5 million right off the top for his liquidation preference because that's how much he invested. So he gets return of capital first. Then you split the remaining $10 million, a third to him, 2/3 to you. Your $10 million just shrank to $6.6 million. Next are redemption rights. Redemption rights essentially force the founder to repay the investment and unpaid dividends, depending on the dividend provisions, at a certain date in the future. This is an example of a downside protection. Remember our 4 exits? If the company only grows big enough to be a lifestyle business, but not a target for M&A or IPO, that might be great for the company and okay for the founders, but not so great for the investor. Redemption rights give the VC an out so that they can put their money into something else. Next, we have conversion and automatic conversion. This section discusses the conditions under which preferred shares convert to common, such as in an IPO. Standard conversion terms allow preferred shareholders to convert to common shares at a 1-to-1 ratio whenever they choose. This allows investors to capture the highest value in a liquidity event, like an IPO, and they're choosing typically between the value of the converted common shares or the liquidation preference we mentioned before. Now, automatic conversion terms are pre-established criteria under which the preferred shares automatically convert to common. So this isn't about it being the choice of the investor. If these terms are met, the preferred shares become common shares. They convert. These provisions may be used to determine at what price a company is allowed to do an IPO, which is then called a qualifying IPO, right? An IPO that meets these conditions, and usually includes provisions about the value of common shares in relation to the original investment and the total valuation of the company in an IPO. Your text points out that whatever the automatic conversion rights are, they should be the same for all preferred shareholders. So it warns against having automatic conversion terms that are different for different classes of stock. The reason for that is that it could essentially, you could have holders of one class of stock holding up the IPO, even if it's in the interests of all of the others. Dilution. Investors may want to negotiate terms that prevent their total ownership from becoming diluted by subsequent investors. In our model of the entrepreneur's journey, all subsequent investments were made at a higher valuation. But that doesn't always happen. When a company raises money at the same valuation as its previous raise, that's called a flat round. If they go to raise money at a lower valuation, that's called a down round. In these cases, the investment is dilutive to the existing shareholders, including previous investors, rather than accretive as you would want. Down rounds are more likely if a company pushes for too high a valuation in its early seed or Series A rounds. The strictest of these dilution provisions change the terms under which the preferred shares convert to common shares at a liquidity event. They do this in such a way that the founder or common shareholders suffer all of the dilution and the preferred investor does not. Here's an example. Let's say that a founder raises money in a Series A and sells the Series A investor 35% of the company. At the end of this, post-money, the founder owns the other 65%. Now, in a standard B round, the company would issue another 35% to a new investor. In this scenario, the founder and the Series A investor both are diluted together. But if the Series A investor had negotiated a non-dilution clause into the A round, then the founder would take all the dilution in the B round. It would look more like this. The net effect of including a non-dilution clause or not on the founder is the difference between owning 42% after the B round or owning only 30%. In a company worth $50 million, that's a $6 million difference. Voting rights. We've already spoken about the flexibility of preferred stock when it comes to voting, but the textbook definition of preferred stock as having no voting rights is typically not true in venture capital term sheets. VCs most often include a provision so that their preferred shares carry votes as if they were already converted to common. The VC's preferred shares carry the upside of the preference, but none of the limitations of the textbook definition of preferred stock. Protective provisions. These are essentially veto rights that the holders of preferred shares have on critical decisions like raising money or issuing new shares of stock. Depending on the investment series, the VC may require a seat on your board of directors. Just real quick, companies have natural checks and balances here. The board of directors hires the senior management of the company. The senior management of the company run the company in order to create value for shareholders, and shareholders vote to elect the board of directors. In a startup, the founder CEO effectively represents all three. She is the major shareholder, she may be the only board member, and she acts as the CEO, the key senior management team member. With VC investments, there are now more shareholders and VC involvement on your board. These checks and balances now start to mean something. Now, similar to protective provisions, VCs may require that certain management decisions, which used to be solely up to the senior management, now require board approval. These might be things like large expenditures, senior management hires, or entering into key contracts, etc. Information rights. Investors may want access to company information. The most extreme information rights are forensic audit rights. They can look at anything and everything in your company. Backing off that, even if they don't go for something quite that extreme, it's super common for investors to require annual financial audits. Limitations on information rights kind of scale back from that point. Registration rights. This section gives investors certain rights around forcing the company to file an IPO in order for them to get liquid, subsequent registrations, and who bears the costs. In practice, IPO underwriters often rework the deal anyway when it comes time for an IPO, but it's very likely that your VC will include a section on registration rights in your term sheet. Right of first refusal, pro rata rights, and pay to play. Here's what these mean. Right of first refusal means that investors have the right to invest in a subsequent round ahead of new investors. Pro rata rights mean an investor has the right to purchase enough stock in the new financing to retain their pro rata percentage of ownership in the company. Pay-to-play provisions mean that investors must exercise their full pro rata rights, or the shares from their previous investment will be converted to common stock. These provisions might seem like splitting hairs, but they can be vitally important to seed and Series A investors who invest at the earliest and riskiest stages. Often these investors spray and pray with their first investments in a company, but depend on being able to make follow-on investments in the companies that are winning in order to generate the returns that they need. They really make their money not on the first investment, but on subsequent rounds when the risk has diminished and when they can capitalize most on the cheap stock they purchased in those early rounds. The conditions precedent. This means that if anything serious is uncovered during due diligence, the VC is not required to go through with the deal. Ultimately, there are sale terms for the actual purchase of the equity in your company, and those are included here under the purchase agreement. Employee matters. You may be thinking that issues to do with employees are mostly operational and the domain of the senior management, but employee issues are the largest category of lawsuits for businesses. They can create liabilities that affect the attractiveness of the deal and for which investors should be able to protect themselves. Another essential employee issue is the recruiting of additional talent on the senior management team. As a result, it's often around the first institutional round of investment that you want to set aside an options budget. Depending on how fleshed out the senior team already is and how mature your company, you may choose something more formal, but at a minimum, you want to set out an options budget. Ultimately, you may have 10 to 20% of the company set aside for employee options. Consider who you need to hire, and consider how many options you anticipate you're going to need to grant before you reach the next round of financing. I've included a chart of what is typical for employees based on their level. This isn't a hard and fast rule, but it does give you an idea of what is customary. Finally, the term sheet is likely to include a proposed closing date, legal representation, who pays for what in the transaction, and issues related to any finders that may have been used in bringing the deal together. And that does it for our discussion of term sheets. I will catch you on the next video.